Before I get into this week's show, I just wanted to let you know that this is the 100th episode of Let Me Explain. So thank you so much for supporting us with your comments, your feedback. We truly do appreciate it. I do hope that you will continue to watch the show. So without any further ado, let's get into this week's episode. More than 4 years after the Union government repealed Article 370 of the Constitution, which grants special status to Jammu and Kashmir, the Supreme Court upheld this decision. You must have read and watched enough and more about the judgment by now, so this video is not about Article 370. It's about another concerning part of the verdict. The judgment, in very mild terms, has threatened federalism. The verdict may have serious implications for other states. Why? To explain all this and more, I'll be joined by Manu Sebastian, Managing Editor of Livelaw. But first, a quick refresher on what happened over 5 years ago. In June 2018, the Mehbooba Mufti government was reduced to a minority after the BJP pulled out of the coalition. Governor's rule was imposed and was replaced 6 months later by President's rule. On August 5, 2019, the President passed an order diluting Article 370 of the Constitution. For over 70 years, Article 370 had given Jammu and Kashmir some amount of autonomy, including a separate constitution. The next day, the President declared the abrogation of Article 370 after both houses of Parliament passed a resolution on the matter. The Parliament also passed the Jammu and Kashmir Reorganization Bill, bifurcating the state into 2 union territories. Several people went to court challenging the abrogation of Article 370 as well as the bifurcation and downgrading of Jammu and Kashmir into a union territory. The Supreme Court has now upheld the decision to abrogate Article 370 and said that the President has the power to do so. We won't get into the details of what the court said about the abrogation of Article 370, but the judgment does raise very serious concerns about the future of federalism in India. And this is because of how the Supreme Court has dealt with 3 important issues in the case. The first is whether the union government can fundamentally alter the nature of a state when it is placed under President's rule. The petitioners argued that during President's rule, there cannot be any irreversible changes made. I spoke with Manu Sebastian, Managing Editor of Livelaw, to understand the petitioners' arguments as well as what the Supreme Court said on the matter.
So it is as per Article 3 that the Parliament can enact a law to bifurcate or reorganize a state. So there is a condition in Article 3 that the views of that concerned state legislature that has to be obtained before passing a law. So of course, the Constitution does not say that the views of the state are not binding or are binding on the Parliament, but at least the views of the state have to be obtained. So in the case of Jammu and Kashmir, what happened was that since December 2018, President's rule was imposed in the state as per Article 356. So while imposing the President's rule, this condition of Article 3 requiring the Parliament to take the views of the state legislature, that condition was suspended. Also, there was one more condition in the Jammu and Kashmir Constitution that the consent of the state is necessary for reorganizing the state. That condition was also suspended. So since the President's rule was imposed, the Parliament acted on behalf of the State Legislative Assembly of the Jammu and Kashmir and made the necessary recommendation as per Article 3. Accordingly, the Jammu and Kashmir Reorganization Act was passed. So in effect, this was a unilateral act carried out by the union government as well as the union legislature, that is the Parliament. The views of the state legislative, that was not taken. So this happened only because of the imposition of President's rule. So now the argument before the Supreme Court was that a President's rule is imposed in a state in order to address an imminent situation of constitutional breakdown of constitutional machinery. So the purpose of a President's rule is to ensure that the governance of the state is going on smoothly, so as to restore normalcy or so as to restore democracy in that state. So it is basically intended as a temporary provision, as an emergency measure, which is to be which is to be taken only in exceptional and rare circumstances. So in the Supreme Court judgment also, so if you read the Supreme Court judgment, even the Supreme Court also acknowledges that the activities or the decisions taken during the president's rule that has to bear a nexus with the ultimate objective of the proclamation, which is to restore democracy or to restore normalcy in that particular state. So if that is the understanding of, or that is the interpretation of the scope of Article 356, then how can that president's rule be utilized to fundamentally alter the nature of a state? So here a state was bifurcated and it was also downgraded to a union territory. So this is a very important issue. This issue was not seriously engaged by the court. This issue was sidestepped by the court. So the court basically concluded the issue by saying that if this argument is accepted, that irreversible changes cannot be made during a president's rule, then the everyday decisions taken by the union government on behalf of a state during the president's rule, all those decisions will be challenged. And this will lead to a situation of administrative standstill. This was the finding of the court. But that issue did not seriously engage with this fundamental argument that the state cannot be split up and cannot be downgraded utilizing president's rule, because that goes beyond the objective of president's rule. That is to restore democracy, restore normalcy and constitutional machinery in a state. And it is not to impose actually a union's rule in a state forever. So this issue was not properly answered by the court, and also court did not seriously think about the implications it holds for the future of federalism, because it has actually established a precedent, a dangerous precedent, I would say.
This is the second issue, that the Supreme Court has set no limits on the president's powers. In the landmark S.R. Bomme case, the Supreme Court set limits on when and how Article 356, that is, president's rule, can be imposed. But in this case, the top court failed to decide on the scope of powers exercised by the union government and parliament during president's rule. This could have serious implications for democracy.
Article 356 itself says that Parliament can act on behalf of the state. Parliament can pass laws on behalf of the state when a president's rule is imposed. This is something, that's a constitutional provision that is clearly spelled out in Article 356. But what is concerning is, what is the limit of this power? To what should be the objective for exercising this power? So this was the issue which the court had to answer in this particular case. So the Supreme Court in S.R. Bomme case clearly laid down that Article 356 cannot be used in such an arbitrary manner. So it can be used only for a very grave situation of a constitutional breakdown. And the court has also explained that, some solitary instances of violence or some sporadic instances would not mean that there is a constitutional breakdown. So court has spelled out certain guidelines, and court has clearly said that this has to be exercised only in a very rare and exceptional circumstance. So that was S.R. Bomme. So S.R. Bomme was concerning, that decision was concerning the stage before the invocation of president's rule. So in this case, Article 370 case, the court had a very golden opportunity to decide on a very novel issue. That is, what should be the scope of power exercised by the union government as well as the union parliament during the term of president's rule. So this issue was before, this was a novel issue. This issue has not been exactly decided by the court previously. So the court could have taken off from the groundwork laid down in the S.R. Bomme case and could have extrapolated the wisdom which the judges in S.R. Bomme case displayed and could have applied to this case. So, for example, when a president's rule is imposed, the governance of the state has to go on. So it is only for that purpose that the union government and the union parliament should exercise their powers, so that there is no complete standstill of administration. You have to take routine decisions, day-to-day administration has to be carried out. There could be other exigencies which have to be met. So it is only to meet these emergency situations and to carry out these routine administrative tasks that the power has been given to the union on behalf of the state. And it is not to make drastic decisions like bifurcating a state and downgrading it. That is not the intent of Article 356. So the court did not clearly define the scope of 356. That is the omission in this case. And court just simply let the issue pass. That issue was not properly addressed in this matter. That is the concern, really. So what is to be noted is that, see, everything is not written expressly in the Constitution. So that is why we have this, judges have, the Supreme Court and the judiciary have evolved this concept of implied limitations. There are certain silences in the Constitution, and so there are certain. So how to read that implied limitations? That is the task of judiciary. So in the SR Bombay case also, these limitations. I mean, Article 356 does not say that it has to be used only in rare and exceptional circumstances. But in SR Bombay case, court realized the danger of allowing this power to be used unchecked. So the court read some implied limitations into Article 356, that it has to be used only in emergency exceptional situations. Such an approach was lacking in this case. So the court should have adopted a similar kind of approach and should have read certain implied limitations as far as Article 356 and as well as Article 3 is concerned in this case. But that kind of a wisdom and foresight was not displayed in this case by the Supreme Court.
The third issue before the court was whether Parliament can downgrade a state into a union territory. What happened to Jammu and Kashmir has never happened in the history of India, where a state was not just bifurcated but converted into two union territories. How did the Supreme Court respond to the matter? Listen to what Manu had to say.
Article 3 empowers the Parliament to make a law to reorganize a state. So that would include bifurcating a state or carving out a union territory out of a state. All those issues are covered under Article 3. So we have also seen in our history of Indian Republic, we have also seen the invocation of Article 3. The latest example, in 2014, we saw the reorganization of Andhra Pradesh. And we have many such examples are there before us. But this issue, whether a complete state can be downgraded to a union territory, this is an unprecedented issue. It has never occurred in the history of India that a full state completely has been converted to a union territory. And the implications are very serious. It's very obvious also when statehood is completely taken away. It means that area will act as a mere province of the union. There is no independent executive control. There is no independent legislative control. Of course, J&K has a legislative assembly, although it's made a union territory, but elections have not been held since 2019. So this was an unprecedented issue, and this was directly arising in this case as well. But court simply refused to answer this issue, simply on the ground that the union government made an undertaking that statehood will be restored to Jammu and Kashmir. And there is no time-bound commitment made by the union also. There is no clarity as to when the statehood will be restored. But still, the court refused to answer this issue by simply accepting this empty promise made by the union government. This, in my view, is a serious abdication of judicial responsibility, because there was a very important constitutional issue before the court, which had directly affected the rights of the people of J&K as far as statehood is concerned. But this issue was not at all gone into by the court by simply accepting the promise of the union. So this has also established a very concerning precedent, because by refusing to answer this issue, the court has basically given a tacit approval or endorsement for the union's activity, that a complete state has been converted to a union territory.
By refusing to answer this key question on whether a state can be downgraded to a union territory, the judgment has raised some very serious fears, especially amongst opposition party leaders. They say that using this judgment, any future union government can impose president's rule and by virtue of having a brute majority in parliament, convert a state into a union territory without even having to consult the elected representatives of the state. So are these fears legitimate? Because in the case of Jammu and Kashmir, the Supreme Court has directed that statehood be restored at the earliest, as well as that elections be held before September 30th of next year.
There is a precedent established as per this judgment. So whether any government will do or not, we can't completely predict, but a precedent has been created. So the court has, in one way, implicitly said that this can be done. So during President's rule, this can be done. So that is the precedent which has been set by this Article 370 judgment. So I mean that those fears expressed by the opposition leaders, I won't say they are completely misplaced. So this would mean that, for example, a future government can take certain actions which are seemingly unconstitutional, and take the benefit of these unconstitutional actions for several years, and can block judicial review by simply saying that, okay, we will restore the status quo ante. I mean, the court should not be concerned about it's not some concession. I mean, that should not be the concern of the court. When there is a constitutional issue before the court, it has to answer it. Court has the duty to answer it. That's why we call Supreme Court the guardian of the Constitution. When there is a constitutional action, when there is an action taken which is violating the Constitution, and when one set of parties are making an argument that this is violating the Constitution, court has to answer that. And you can't evade a decision on that issue by simply pointing out that, okay, they have agreed to restore the status quo. Supreme Court is the final arbiter of the Constitution, and Supreme Court has to protect the Constitution also. And so, by not answering this issue, the court has actually given an endorsement for this action, so which can be adopted in future also. So that is another danger of such an approach. And as far as this direction to restore statehood, there is no time-bound direction given. It's just an empty, a very open-ended, vague kind of a direction that it should be done as at the earliest. What does it mean at the earliest? Is it 1 month, 2 months, 6 months, 5 years, 10 years? What is this phrase? So the court has to clearly define a time limit at least. For elections, a time limit was given, but for this case, as far as statehood is concerned, there is no time limit given. So when there is no time frame given, the union can simply, drag its feet. So that is another issue.
What happens to Jammu and Kashmir, and when statehood will be restored? These questions will hopefully be answered by the union government in the coming days. But for states across India, this judgment has posed a grave threat to federalism and has possibly endangered the rights and powers of states. That's all for me for this week, but once again, thank you so much for supporting our show. So if you do value the journalism that we've been doing here at the News Minute, do become a subscriber. Also subscribe to our YouTube channel. And as always, if you like this video, hit the like button and share this video with your friends.